Today you have two should I say, two hosts of the show, except that the other one is playing the role of a guest. And we'll be dealing with the Jake Bungalow controversy, as we have been calling it. Do I need to give you too much of an insight into this? We all know what has been happening. The Supreme Court has spoken, and the government of Ghana, it seems, has also spoken at this time. The newest dimension to this issue is that the government has, through the Minister of Information, released a press statement or a press release with the heading, "Government will not sell property to Jake Obechebi-Lamte." And we all know that that's what we've been discussing for some time. There's two ministers, deputy ministers, as it says, went to court and said Jake Obechebi-Lamte really acquired some property, and which was tainted with fraud and all manner untoward, basically. And the Supreme Court said no, it didn't see it that way, even though he said it does not condone certain aspects of the thing. We will talk about that generally. Question of forum also came up. Perhaps this matter should have gone to Shraj and all the Supreme Court and all those questions. But as I said, there's a press release, and I need to read the press release to you at this stage. It reads, and I quote, "In the supreme interest of the people of Ghana, and taking cognizance of the Supreme Court ruling in the matter of Mr. Jake Obechebi-Lamte's immoral acquisition of a state property he occupied as a Minister of State, Cabinet, at its sitting today, Thursday, May 24, 2012, has decided not to sell the property," and the "not" is in capitals, NOT. "The property in question thus continues to remain the property of the state. Cabinet has also decided that no political appointee should ever be allowed to engage in any such unacceptable transaction." This is signed by Phrase Bafo MP, Minister of Information. He's on the telephone line. Good evening to you, Honorable. We lost him, but I will get him back on the line. I'm sure you have the message basically on the, so that we have the matter. It's quite clear to you, and that is what it is, and that's what we are discussing tonight. We also be joined by Mr. Ayikwe Otu, I should actually say Honorable Ayikwe Otu, former Attorney General of the Republic of Ghana, and he was on the side of Mr. Jake Obechebi-Lamte in this matter, and he's on the line as well. Good evening to you, sir. I hope you are doing well.
Good evening. Good evening.
Thank you for joining us. In the studio as well, I have Mr. Chris Akume. He's a lawyer, and I'm sure we all know him. Mr. Akume, welcome to the show.
Thank you.
All right, and on my immediate left, Samson Ladi Ayenini, who you know also does host this program on occasion. Is here with us. He's a lawyer as well, and we'll be dealing with these issues. I think that Honorable Phrase Bafo is also back on the line with us. Good evening, Honorable Phrase Bafo.
Good evening.
Thank you very much for joining us. I'd like to begin this discussion with you, since as a matter of fact, this press release signed by you is the reason why we are having this discussion tonight.
Yeah.
Questions have been raised about the whole posture of this statement. Basically, some think that you are calling into question the position of the Supreme Court by not you going back to the Supreme Court, but basically saying that political power is in your hands and you use it your way. What's your response to that?
I think with the deepest respect, we uphold the law of the land very highly. I think you yourself are a lawyer. It wasn't a question of whether the purchase of the land was illegal or not. It was about whether there was a conflict of interest. And this was at the time that our party was not in power. And so the gentleman at that time, it was a private sort of legal issue. Now they are all members of our party. We have not made, as a government, have not made a statement or made any issue of the fact until the Supreme Court came out with the fact that there was no conflict of interest. But right from the start, when this thing happened, supporters of our party and our party itself were against it because we thought it was immoral. We thought it was unethical that for years, since we've had properties that have been assigned to government ministers for their tenure of office, that they would then later on turn and buy those properties. As I stand, I'm a son of a former senior civil servant, and we lived in a house in the 1950s, before independence. and the house we lived in is assigned to a civil servant or the government. So we felt, and all well-meaning Ghanaians felt that it wasn't the right thing that if you lived in a government property and you felt comfortable there, you would want to buy that property. I myself I've been aghast at the fact that any time a minister in recent times has used any property like a car or something, wants to take it home, I think that is not the purpose of being in government. You have to have a certain understanding that power is a transient thing. It is not a permanent thing. NDC are in power today. We could not be, may not be in power in the future. And therefore, anything that belongs to government should stay with government unless there is a proper moral, ethical, and legal reason for it. The Supreme Court made a statement. They said that there wasn't a conflict of interest as such because that was what the plaintiffs thought. But we felt that morally and ethically we should make a stand in cabinet today. And it had nothing to do with partisan considerations. What we felt was that it was wrong for government property to be sold at a whim to people who had used that property not for a long time, but because they felt they were comfortable there and that's what they had to use. Now I want to give you, I'm not going to go into legalese, but let me talk to you about the fact that the International Students Hostel opposite the airport was land belonging to the Ministry of Foreign Affairs that had been given by one of the previous governments. And it was sold to individuals. When we came, we revoked it, and that property is now being used to build the Foreign Affairs Ministry. What we're saying is that we cannot be cavalier with government property. And so therefore, it is not at the whims and caprices of those who occupy that if we set that precedent, then it's a problem. I know people are talking about the redevelopment of Accra, the plan and all that kind of thing. I am not going to go into it because I'm not the Minister for Local Government and Rural Development. I'm not the Minister for Housing and Water Resources. I'm the Minister for Information. We sat down, we deliberated, and we came out with a conclusion, and I've put that across. And that is what I'm saying, that our government believes that there's a moral and ethical issue here. If it's taken to court, we're ready to defend our stance. But I don't think that the Supreme Court is at odds with us because we're not talking about that particular judgment. We're talking about a moral issue of the protection of government property in the supreme interest of the Ghanaian people.
Stay on the line with me and let me bring Honorable Ayikwe into the picture. Honorable Ayikwe, if you're still there, what do you make of the initial comments by Honorable Fritz Bafo?
Hello.
Hello, Honorable Ayikwe.
Can you hear me?
I can hear you very clearly.
Very well. You see, I am very sad today.
Who am I talking to?
Because I do not see why, when we made so much progress from 1993 to today, we'll be turning back the hand of the clock of constitutional democracy. We have all sworn to keep this constitution, to uphold it, and to defend it at all times. We took the history of this country into consideration when we were writing our constitution, and we tried to prevent some of the issues that arose in those days that we felt were unpalatable. If the President of the Republic can become the final judicial authority of this land to sack judges because a judgment has been given which he found not to his taste, then we felt that there is no judicial independence. This constitution, therefore, made provision for judicial independence, both administratively and financially. It also ensured that judgments of the judiciary becomes the final orders when we're talking about judicial matters. Now, this policy is talking about, which had to do with the lands at the hostel, I dare say it's nothing more than a policy of a one government which another government can easily change. You can always make policies and decide to change the policies, but you don't interfere with the decision of a court. What has happened in this case is that the two deputy ministers invoked the original jurisdiction of the Supreme Court on Article 2.1, said that an act had been done which infringes Article 23, 296, 35, and all kinds of constitutional provisions were looked at, and they wanted a declaration that there had been cronyism, there has been bias, there has been corruption, there has been abuse of power, and all that. The Supreme Court came to the conclusion that Jacob Echebilamte did everything right. He bought the property which was leased to him by a leasehold document signed by the then chairman acting on behalf of the president, Juan Kumi Bruce. He paid for it. At the time, he was no longer a minister of state, and therefore, the property belongs to him. Today, a parliament, a cabinet made up of lawyers, the president, the Mumuni, the attorney general, I believe other people who are lawyers could be in the cabinet. Fact, and without regard to our constitutional provisions, decided to elevate themselves into a final judicial authority on the matter to say that they have taken cognizance of the Supreme Court, but they are going to play something they call morality, and that in their view, what has happened marks of immorality, and therefore they are not going to abide and to obey the orders of the Supreme Court. I beg to differ. I beg to differ. They are taking us back with the greatest respect to all of them, to those dark days. Hello?
I can hear you very clearly.
Yes, to those dark days that we didn't like in our history. So please tell them that they don't compare policies or elevate policies into that of judgments of the Supreme Court. If they have done that, there would have been consequences. And I'm saying, and I'm hoping that their lawyers, including Chris Akume sitting in your studio, would advise them that what they are doing is clearly contemptuous of the Supreme Court, as well as an unconstitutional act that they have decided to embark upon. That's what I'll say for now.
Okay, I need you to also stay on the line for me, and I'll be very grateful for that.
I didn't know who was talking.
Okay, Honorable Fritz Bafo, that was Honorable Ayikwe Otu.
Yes, the thing is that there was an element of wanton bombast there. The thing is that when it comes down to the nitty-gritty, I'm not going to go into the legalese of the issue. The thing is that we have taken a decision. If they want to take us to court, they can take us to court. We said in cognizance of the Supreme Court decision, because we realized that the case was before court before, but we were totally against the fact that government appointees or political appointees could buy properties that they were given to in custody for the tenure of office. And so therefore, that was what we're working at. I'm not here to contest in terms of legalese. I'm a journalist. I have a little bit of knowledge about law, but I am not going to split hairs with him over that. What I am saying is that you are given a property. It's a property that you're going to stay in while you are in office. And if they say that Jake had left office before he bought it, the thing is that he had some direct relationship to that property, and that the property was refurbished at the cost, at certain cost by state, and it had been made palatable or desirable for him to live in. I'm not here to argue the legalese of it. If he says it's unconstitutional, he should take us to court. We've taken a certain decision. We've taken a certain decision in the supreme interest of the Ghanaian people. Property is hard to come by. Civil servants and public servants have to have places to live in order for them to make themselves comfortable in terms of their tenure of office, which may be a year, 2 years, 3 years, 4 years. If you move into a house and you feel it's desirable and you want to buy it, then we're setting the wrong kind of precedent. And we've been against it even before we came into power. But we had to wait for the Supreme Court to make a certain decision, and that decision was not based on the fact that it was legal for him to live in the place, but it was because of the conflict of interest. I don't want to go beyond that because, as I said, I am not a legal eagle.
But let me ask you, even as you admit that you are not a legal person, let me still ask you, you're Minister for Information and this statement has come from you, signed by you. When you say that the government has decided not to sell the property and all the issues that we hear with respect to the fact that there's already an agreement in place, there's a lease agreement in place that has been signed by the duly authorized person so to do who did it in the name of the President of the Republic of Ghana, are you saying that at this stage what you are doing is that you are reversing a step that you are taking, which has taken full effect, which has actually been effectuated? What are you doing now?
With the deepest respect, I am saying that I am the spokesman of government. We sat down and deliberated on this issue. I am not at liberty by the oath of office to be able to reveal the deliberations openly. I am saying that we have decided that we are revoking the sale of that building. It still belongs to the government of Ghana. And I will end here by saying that if there are any legal implications, they should take us to court. And I'll leave it at that. Thank you very much and have a good evening.
Honorable Fritz Bafo, can you stay on for a bit? Well, interesting. That's your answer right there. I mean, and you can hear the beeping sound for effect. That's what the producers do and the directors do for effect. So, so you got that. I mean, absolutely, I had not come to the end of the discussion with him, I should say, but Honorable Ayikwe is still on the line. And I'll go back to him, Honorable Ayikwe. Can you hear me, sir?
Yes, I can.
Okay, great. But basically, there will always be a question as to what happens in relation to such a ruling, which, as it says, is quite separate from its enforceability, as we always know. That enforcement is also a different side of things. And that when you look at the balance of power, so to speak, between the arms of government, that it seems as if the court sometimes may get out-muscled in a way, practically. Is what happens to us, that's such a ruling, it says A, B, C, D. Are you suggesting to me then that the government, even though you say that it was legally and rightly performed, and you and I the other day were talking about quoting some Latin, which I will spare my viewers today, of functions officially performed and fully effectuated, that the government at this stage cannot resile or turn around and say, well, for A or B or C reason, we are ready to go through whatever it means, whatever we have to suffer for it, but we cannot sell it in the name of, in the public interest?
I'm only going to repeat what I've said previously. I said policies can be made and the policies can be thrown away. It is those of us who make the policies who decide whether it's working in our interest or not. When laws are made, it is not for us to say that this law is immoral. As for me, I will not respect the law. You'll be punished for it. You understand? We don't care about the morality of any law. We want to declare the law, enforce the law. In this case, what the government of Atta Mills is doing is that it is elevating itself into the final judicial authority of Ghana, which is against the Constitution of the Republic of Ghana, which he has sworn to uphold and defend at all times. It is worse than anything that Kennedy Ajipo might have done. This is my worry. You can't do that. We have a constitution by which we have all agreed that we are going to be ruled by that document. And at his swearing in, he swore to uphold and defend that constitution. There are clear provisional provisions of the Constitution, saying that you don't do that. Leave the final judicial authority to the judiciary because of our past history. In recent times, if you remember the case of Bungalow, he was a judicial service officer who was removed from office by the president. They challenged it. They went to court that they had no power to touch it. The Supreme Court agreed with them that he had all the protections as a judicial service worker and cannot do what he did. It was set aside. Mr. Bungalow is still serving in the judicial service. Please. My worry is that they have lawyers, and I suspect that they should be advising them. So when you are going to tread on the policy which has become a judgment of the Supreme Court of the land, you don't still say that it's an ordinary policy and compare that policy with what you did at International Students Hostel. Nobody raised any finger because it was a mere policy which was reversed. Indeed, when the NPP took over in 2000, they had a policy to sell cars to themselves. And many of the ministers had bought the cars. We were able to reverse that policy, and when the cars were below 2 years, then they could not be sold. All the cars were seized. We don't have a problem with the policy, but we are talking about a judgment of the court. And you cannot compare policies to judgments of the Supreme Court. I beg to differ.
Let me come to the studio, and as I said, I'll still be happy if you can stay on the line for me. But as you spoke and made your submissions, one of my panelists here, Samson Ladi Ayenini, I think had some form of a reaction to what you were saying. Samson, you seem to disagree with Honorable Ayiko on some points. What's your point of departure from what he said so far?
And I would like to pose it in the form of a question to the Honorable Leonard Senior. I am seeking some education here. In the majority opinion, which was delivered by Justice Brobe, I would simply quote his very last line, where he says that for the foregoing reasons, after having established that the various allegations and claims that were made had not been proven, then he says that for the foregoing reasons, the plaintiff's application for the reliefs fail in toto, and I would dismiss all of them. This constitutes the opinion of the majority of the Supreme Court. My question to you is this. Seeing that the decision of the Supreme Court is to this effect, a dismissal of the plaintiff's claims, and does not make any specific orders seeking to enforce, as it were, Jake's title to that particular property. Should you be heard to say that the Supreme Court had validated Jake's title to the property?
The Supreme Court said that he erred in acquiring the property. If you've read the judgment in total, did you hear that the minority decision dealt or dwelt more on the policies underpinning the work of the Land Commission and the way they acted when they gave that property to Jacob Echevilante? Have you read that one? So everything had to do with that property. Why did they go to court in the first place? They went to challenge the acquisition of that property, saying that it had to do with, you know the words that they use, abuse of power, corruption, so and so. At the end of the day, they sought to bring a policy or a cabinet extract to the effect that there had been a previous policy to the effect that government officials should not acquire property. It was made in 1999. It turned out that cabinet minutes, those cabinet minutes were not properly authenticated. So at the end of it, that was also thrown out of the window.
Okay.
So we were left with nothing in support of their claim.
Okay.
And let me just land on this one.
All right.
Mr. Justice Broadway ended by saying that at the time Mr. Jacob Echeverria acquired the property, he was no longer a serving minister.
Yes, and he even went ahead to say
380,000 Ghana cedis for it.
Okay, and he said also that that particular position you just said, that Jake Obeche-Bilamte at the time in 2008 was not a serving public officer and had actually left that office and was contesting the MPP presidential primaries. So he was then an ordinary private citizen. But on all the issues that were raised by the plaintiff, the question of a conflict of interest, the court had found, and on that question, they were unanimous that the proper forum to have gone to for the determination of that was Shraj. And then the questions of cronyism, arbitrariness, capriciousness, discrimination, corruption, abuse of discretionary power vested in a public officer, Justice Brobe found that all of these, no practical attempts in terms of evidence were adduced to support those claims. And so they failed. So my question is that they were seeking the declaration that, to the effect that what had transpired was null and void and of no effect. And the court says, we have not been provided with evidence to be able to make that determination, and so your application fails. Does that amount to an order of the Supreme Court validating and reinforcing Jake Obeche-Bilamte's title to the property?
Honorable Ikwetu, hold on right there, Honorable Ikwetu, for me. What I'm going to do at this stage is I'm going to ask Samson himself what his own view is of the matter. Because seriously, we may end up doing 45 minutes of this where I can sense that he disagrees with what you're saying. I want your own view because you are here as a guest tonight. What's your own view of that matter? What is your suggestion in there? Okay. Because we all have Article 2.4 at the back of our minds. And somehow I can sense that you think that this does not fall under Article 2.4. Because Article 2.4 uses the words, or if for the benefit of viewers, that failure to obey or carry out the terms of an order or direction
of the
made
Supreme Court
or given under Clause 2 of this article, which is Clause 2 because the Supreme Court, because people taking there for whatever of this article, constitutes a high crime under this Constitution and shall, in the case of the President or Vice President, constitute a ground for removal from office under this Constitution. And I know that Honorable Ikwetu has actually made reference to that on the Joy FM interview. So I guess that's where you are coming from. What is your own view, Samson? Are you suggesting that this does not amount to a refusal to obey a direction or order of the Supreme Court?
With the greatest respect, Ni, I am privileged to be sharing this platform with very senior learned colleagues like Nia Ikwetu himself. And I was seeking some education to the effect that I have read the judgment, I have read every bit of it, and I come to the conclusion that for the majority decision, the bottom line is that the declarations that the plaintiffs, Samuel Okudzeto-Ablakwa and Dr. Omani Boama, were seeking, which, when put together, was only to the effect that they wanted the court to declare the purported sale or outright transfer of title to Jake Obeche-Bilamte in the property to be declared null and void and of no effect because of the issues they had raised. Now the court says that's the majority decision, which is the decision of the court, is that you were unable to provide evidence to prove those claims. In fact, Justice Brobe says that what they did was simply to rely on the bare allegations without any evidence to prove same. So, if this is what had transpired, you are unable to get what you are seeking this court to do for you. I am thinking that in the end, we do not have the court making specific orders validating Jake Obechebi-Lamte's title to the property. I admit that at this point, it is clear on the face of it from what we have heard that Jake has a perfect title. He has a title I suspect is superior to which other title someone else may have. And it is worrying to discover that there is a cabinet fiat seeking to stop or to say you are no longer going to sell a property that already has been sold, and coming fly in the face of the Supreme Court's decision. However, my difficulty is that it appears to me, by my little understanding, very few years experience of the law, that the ruling or the opinion of the Supreme Court does not have the effect of validating Jake Obechebi-Lamte's title.
So what you're saying in effect then is that government saying we have decided not to sell or not going ahead with what we consider to be the view of the Supreme Court will not amount to any to refusing to carry out the order or direction of the court, because there's none.
I suspect so, in part.
Is your view. Honorable Ikotu, what's your view on this one? And I'll bring Chris into the discussion because he's been quiet for too long.
Yes. You see, when I was a young counsel, I didn't want to get involved in huge political legal matters because I realized my own limitations. I mean, we should begin to be humble enough to say that we are still young and we are learning. After all,
I think that's what Samson said, actually.
Nobody has a monopoly over knowledge, but at least experience can shape us into understanding certain issues. Now, what was it that the people were complaining about? The chronism, the abuse of power, the corruption, the lack of discretion, all the things that they heaped on the head of Jake. What was it about? Was it not in respect of the acquisition of that property? And for the Attorney General, he even produced minutes to the effect that no government official could acquire government interest in any government property except with the approval of cabinet. And that to the extent that Jake Obechebi-Lamte did not have cabinet approval, that transaction was null and void. Ask Ayeni if he has read it. This was set aside. And the majority said they found as a fact that the property has been properly leased to Jake Obechebi-Lamte, and that official duty is presumed to have been officially done.
Presumption of the approval.
They had no other evidence to the contrary that that official duty had not been performed. The property remains, therefore, title remains agent. Now, cabinet goes to sit and says, as for that, we will not recognize it. We will not. What are they doing? And that property does not belong to Jake. That is a desperate slap in the face of the Supreme Court. Because as you look at what we call the ratio dissidenti, why did we go to court? What are the facts? What was the law? What was it that was decided? Put all of them together. It was only to deal with whether or not Jake properly acquired that property. And the people said you could not prove that he did not acquire it. What is the effect of that? It means that he properly acquired it. They even went ahead to cite. In fact, Justice Atukuba read the lease itself. He read it as part of his opinion. So what is my friend talking about? What is he now saying? That he wants another declaration? That declaration itself is evidence in the judgment that you were not able to prove anything. The property has been properly acquired. It is for him. He goes home victorious. The following day, you go and hide somewhere and tell us that there is something about morality. Morality and law are not the same. Adultery may be a ground for divorce, but is it a crime for you to go and kill somebody for sleeping with your wife? Morality and the law are not the same at all. They are poles apart. And I'm sorry, I'm saying that to elevate themselves into a final judicial authority of this country, with due respect to all those involved, is to turn the clock back. We never did anything of the sort. When judgments are given, all you do is to respect the judgment. Disagree with that, the opinion, but respect it because you don't have final judicial authority. But to come out boldly and tell us you are defending the people of Ghana and then cite examples of policies but not judgments of the court to buttress your point.
Let's
does not jive at all.
Okay, let me take the views of Chris Akume, who hasn't spoken for almost 3/4 of an hour this time, and I must apologize extremely to you, but I realize you're making copious notes. This is a time for you to let the notes out.
Yeah, thank you. I think the whole issue was based on whether the transaction between the government of Ghana and Jake Bechabilante was morally upright, whether it was not capricious, whether it did not smack of cronyism and the rest. So the applicants went to court for a declaration. Now, what they went to do, or they were seeking what I would describe or normally describe declaratory relief, and that was refused them. Now, the position now is that once that has been refused them, the court, from my perspective, should have gone ahead to make an order. To the extent that the court did not make any such order, I mean, I don't see what is going to be enforced at law when no such order has been made.
But the question is there anything to be enforced at law for Jake? He is sitting somewhere, he has a property, he is enjoying it, he has title to it, he has documents covering it. Somebody says that you don't have it.
The property.
No, you know what I mean?
He's not even
it
in
may
possession.
not be physical enjoyment, fine, but he has it, legally belongs to him. And you say that you don't think he should own it, and you go to court and you are refused. How does that affect Jake's rights? It doesn't take away his rights, does it?
It does not take
Absolutely.
the right
So,
to ownership of the property.
That's the
but
point.
what is to be enforced? You know, and if you look
He was
at
not looking for an
and if you
enforcement,
look
was
at
he?
if you look at it, if you look at the judgment, part of it is referring the applicants to go to Commission for Human Rights and Administrative Justice.
That's right.
To seek justice on issue or redress on issue of conflict of interest,
Yes.
abuse of power, and so forth and so on. So you can even see that from that perspective, the matter is not conclusive. It is not conclusive.
But does that challenge Jake's title? I mean, is Jake supposed to wait for something?
Whether it challenges it or not, the fact of it is that, you know, there has not been any validation of Jake's title. That is the point I also make from after reading or perusing through that. It does not validate the title. And let's also look at this aspect of it. I have listened to my learned senior who has pontificated so loudly that once a transaction has gone on or has been effected, it must be respected. That's what he's saying. I mean, so it does not matter whether that transaction is with blemish or frowns upon the law or does not take into consideration public interest, public morality, and the rest. It must be respected. I mean, I'm a little bit, and I don't accept that position. That's exactly what I'm saying. You see, that property in question, if I may make a reference to it, you see, was part of the property acquired by the colonial government on 29th of July, 1929. it was for a 50-year lease term, which lease term expired on 28th July 1999. And as we speak, it has not been renewed. It has not been renewed. Now, my position, therefore, is that once the property, the lease on the property has not been renewed, it definitely, the government has got no interest and therefore no control in this property. But that does not stop the government from going back to acquire the property at a later time. Because as you know, all property are vested in the president on behalf of the state. At any time, the government can go in to acquire any such property for purposes of, for the interest of the nation or the people of Ghana. Now, if you come to this point that one, there has not been renewal, then automatically, I think that this particular property has gone back or reversed to the people of the Osu traditional area and remains their property. What you don't have, you cannot give. That is a basic principle in law. What you don't have, you cannot give. So assuming that, there has even been any transaction on that land by the government to Jacob Lamte, my position is that once there's a lapse, once the lease has lapsed and it has not been renewed, therefore the owners of this property presently are the people of the Osu traditional area.
Interesting views that we are getting
now,
tonight.
Let's go on. And I am saying that if for one reason or the other...
It's quite an engaging show we have tonight. And you can call it a Jake Bungalow Wahala. It's one of the headings suggested for tonight's show. Chris, you were making a point and you're just about to...
I was saying that to the extent that the government has not taken any step to renew the lease, I mean, the government has got no control and ownership over this particular land, and therefore it belongs to the people of Osu. To my mind, any transaction...
Could Jake be a bona fide purchaser for value in this respect?
He could be. But then what I'm trying to say here is that, once the property was acquired from the people of Osu for purposes of development or improvement upon the lot of the people of this country, and that is always the policy behind acquisition of government lands, and the government does not have any use for this land any longer, and that is mostly the reason why it has not been renewed. That land, if there should be any proprietary right or control over the land, it must be the people of Osu. Now, if for any reason the government, through its representative, that is a lands commission, it first a transaction on this piece of land, and the government has now come back to say that it does not intend to sell the land any longer. The question I want to ask my learned senior is that, does the vendor not have a right at any time or the other to withdraw from a contract, whether valid or not?
When the sale has been concluded?
If the sale has been at any time
you cease to be the vendor.
I'm coming. Once there is...
If you sell, you are no more the vendor.
If you sell...
You've gone. You've washed your hands off.
No. What I'm saying that it has not... The government has not disposed of its interests.
The person I bought my car from can't come back and say he's changed his mind.
That is true.
The car is now registered in my name. It's completely mine. Yeah. He needs to come and convince me to sell it to him.
But under public policy, you and I know very well that the government of Ghana, who exercises control over this land on behalf of the people of Ghana, and in the interests of the people of Ghana, can come back and say, look, for this reason or the other, I want to have the land back. Now, I think the position of government must be applauded. I think the position of government must be applauded because it is a response.
But Chris, before you go ahead, let me ask you, what you're saying does not amount to deciding not to sell the property. Because what we have in the statements is, I decided not to sell the property. If the property has already been sold. You see the point?
Yes.
Nothing, like you say, you are raising principles. I mean, there are certain cases, like G and others and all of those things. Normally, when I'm in this seat, I don't like to do those things. But the truth of the matter is that we have even had our courts pronouncing that the trust issues, when the state is involved, is of a higher kind. The principles we talk about are always of a higher kind. It's not as a transaction between individuals and all of that. So you may have a good point there. But indeed, is it a matter of deciding not to sell when indeed it has already been sold?
The issue is whether the sale has been perfected. That is another issue.
Okay. And to you, it has not?
Well, I am not privy to all the facts to ask to whether to state emphatically whether the sale has been perfected or not. That is another aspect of it. But you see, we all believe in the rule of law. You understand it? And I will be the last person to encourage any official of state to, disrespect the rule of law.
Okay.
I sincerely believe that if we allow institutions of state like the judiciary, the executive, and the legislature to perform its functions without any interference, it will do well for this country. But at the same time, these institutions must be a check on one another. Must be a check on one another. Okay. Now, here we are with the judges in the Supreme Court, the highest court of the land.
You should be running up for me, Chris.
Saying that they have not seen any conflict of interest. They have not seen any conflict of interest. They have not seen any element of corruption in this transaction.
Yes.
And that at the time that the transaction took place, Jake was no longer a minister of state. Are they saying that his interest, his influence does not loom any